coming in. And as members come in, there's a, hopefully if you'd let us do an advance name tent and a packet, we'll have the members introduce themselves because we have some new faces here. So we'll start with not the newest of the faces, but certainly one of the best ones, Representative Fisher.
Thank you, Mr. Chair. Peter Fisher, House District 43A.
Thank you, Mr. Chair. Amy Waswick, House District 38B.
Thank you.
Mike, representative from 45B.
Steve Elkins, 49B.
Tina Liebling, 26A, Rochester.
Jen Schultz, Duluth, 7A.
Thank you, members, for attending tonight. These two hearings come at the request of Representative Hortman. And they come at the request of Representative Hortman because of issues that we have faced for a period of time, at least the last decade and beyond. We're going to start tonight, as we started a decade ago, by going back to the National Council of State Legislatures and having a review of what was done 10 years ago with the Government Operations and Reform Committee. When I chaired the committee, we had 8 hearings in the interim, all on legislative process reform. We then issued a report of suggestions of changes in the rules. And since 2007 and 2008, while there has been some incremental improvement, at least in adopting certain rules, our performance has been less than stellar. And I use the example of the past session where we set another record of 4,542 bills being introduced into this body. And again, we've seen a decline in the number of bills being passed. I just use that as an example of sort of the tip of the pyramid of problems that we have to face with reforming this process. So Representative Wagenius, we had folks introduce themselves, so if you would do that, you're next. And if you'd pull the mic up there.
Jean Wagenius from Minneapolis and Richfield.
And Representative Mason's here too, so.
Oh my.
Thank you, Representative Schultz. Before we began, we had Brenda Erickson come for a period of time, not just one day. We had her come actually for several weeks. We had her come at the end of the 2007 session, so she could take a look at how our session ended then. And then she worked with us over the interim of 2007 and into 2008 on hopefully beginning to take a look at what our options were to improve the legislative process in Minnesota. I know she's going to introduce herself, but she's actually a product of the Minnesota legislature. So I'm not going to give the number of years, you can, but it's been a while. She worked in the Minnesota legislature. And I recall one of your statements after watching the end of the 2007 session, when you said, and of course it was in my office, it was a legislature you no longer recognize. And that was in 2007. So with that, I'll introduce Brenda Erickson and thank her again for coming all the way from Washington, D.C. And I'll turn it over to her. So please identify yourself for the record and begin your testimony.
Thank you. And thank you, members, for being here. It's my pleasure. Again, I'm Brenda Erickson with the National Conference of State Legislatures. I am a former Minnesota resident. I grew up here actually in Grand Rapids. And all my family still lives here. I have worked for NCSL for 34 years. I have been their NCSL's expert on legislative process for 30 of those 34 years, and I did work for the Minnesota House of Representatives for 5.5 years from 79 through mid-84. Hence, as my colleagues say, my interest in tied chambers, because that was my first experience with the legislature, was the tied session that you had in 1979. And again, I want to congratulate all the members here who are been elected or reelected. what you are now and what I'm going to talk about are things that you can think about when you're looking at your legislative process and potential ways for you to reform this. If any of you were here 10 years ago when I spoke, a lot of this will be very similar, if not exactly the same, because in some cases things have not changed nationally as far as process, because some of the things I'm going to talk about are constitutional in nature, and those are very, very stable generally. As members, you have joined what I like to call the legislative institution. And as part of that, you are now part of Minnesota's legislative history, which is important to think about because this is an institution. And it's one that I'm, because I have worked here, very fond of and have a lot of hope for, as I do for every legislative institution, and especially the state legislative institutions across the country. I am, as what my colleagues like to say, a parliamentary geek. I love the process. And I love the state legislative processes, hence the reason I've been involved with it for 40 years and a student of it for 40 years. As I said, what is an institution because you're now part of it? An institution is, as defined by the dictionary, an established official organization having an important role in society. But what is the legislative institution? Anybody want to guess as to what the legislative institution is? You are. You are, as members of this body and the legislature here and the staff who are sitting here with you, you are the legislative institution. And with that comes a lot of responsibility because you have given up some of your personal rights by becoming a public official. So now everything that you do and everything that you say not only reflects upon you personally, it reflects upon this institution and your district. And I think those are very important things to remember, that in your role as a public figure, you have given up personal rights and you have a broader responsibility to this institution and to the people that you represent. You are their voice and their face within this institution. Going on from that, kind of setting that as a stage, the question next is, what is parliamentary procedure? Because that's one of the things that you're here to look at, is your process and your procedures. Generally, parliamentary procedure is simply the rules governing group decision-making. Because again, that's what you're here to do, is to decide. The legislature establishes the laws for the state. They determine the things that are important to a majority of the people that are in the bodies. And again, as a representative of your districts, you are the voice and the face for the people that you represent. The other thing to remember is that parliamentary process and procedure is what we call tried and true. It is not something that has just developed overnight. Minnesota's institutional history and parliamentary process has been developing since Minnesota became a state, and most people would even argue it started even before that, when you were a territory. So I think, again, this is something that has been developing over years, and it has been The tires of your process have been kicked many times, but it never hurts to take a look at them and make sure that the air in those tires is sufficient. The other thing to remember is that parliamentary procedure is not something that is imposed on you. You have a constitutional right as a legislature, and in fact, each chamber of the legislature has the right to adopt its own processes and procedures. Here in Minnesota, that's established by Constitution, Article 4, Section 7. So you have a constitutional right to establish your own rules and procedures, which actually gives weight to those rules and procedures. According to Mason's manual, in fact, your process and procedure trumps anything that's written in statute that would control your process, because one legislature technically cannot bind the process of a subsequent legislature. So again, when you're looking forward and looking at these, you have a lot of power in determining how you act and how you want your bodies to act when they're doing their work. There are things, however, that you want to look for, because there are some indications of why a rule or procedure may need to be changed. And it's always good to look at those, but also know and understand the history of your rules and procedures. I'm going to quote somebody who many of you may know or have known or have heard of, Edward Burdick, one of my favorite people in the whole world, who used to say the best parliamentary procedure is one that is simple. It should be in writing, be clearly stated to avoid confusion, interpretation, and be available to everyone, not only to you, but to the public and the staff of the legislature as well. That being said, not all rules are good rules. Just because a rule is old or new doesn't make it good or bad. They should be helpful to you as an organization and the members. A bad rule is one that basically impedes the accomplishments of the organization, that gets in the way of the things that you want to do frequently. For example, rules should reflect your actual practice. If you have to suspend your rules frequently, if there's frequent points of order because a rule is confusing, there are multiple interpretations of a single rule, if there are frequent references to your precedents, your customs, or if you have to go to your adopted parliamentary manual frequently, those may be indications that you may need to look at that rule and fix it, because it's not reflecting what you actually need to do or how you want to do it. That being said, again, just because you have a rule there and you never use it doesn't mean that that's something that should take away, because that rule may have been there for that 1 in 100-year event that if you don't have that rule, you're going to have a lot of trouble. So again, knowing the history of where your practices come from and why they're in place is equally important as knowing how much they influence and work with your body. The other things that can cause changes in rules are actually a change in your legislative structure, i.e., you may have a constitutional amendment that changes the length of your session, changes the terms of your members, changes how you have to process bills. Those things are also going to be indications where you probably may actually have to change your process because it is a constitutional requirement you do so. Changes in leadership, changes in party control, public dissatisfaction with something. I actually live in Denver, and in Colorado we have citizen initiative. And as a direct result of some public dissatisfaction with some of the legislative practices that had been in place, there have been citizen initiatives that have literally changed the Constitution and changed our practice. So again, being aware of what the public thinks of how you're doing things is very important as well. One of the things that we've talked about and has been brought up when I was talking with Representative Pulowski and often with other legislators across the country is legislative logjam or end of session logjam. And I go, yes. What do you want to do? And they go, we want to get rid of it. I said, good luck, because it doesn't really matter what kind of legislature you have, whether it's a full-time legislature or a very citizen part-time legislature, you're still going to have end of session logjam, because it is pretty much almost a built-in event that occurs by the simple negotiating practices that come with developing legislation. Can you mediate the extent to that logjam? Absolutely. But you aren't probably going to be able to avoid it entirely, because many times the most controversial bills and the biggest bills are the ones that come at the end of session. And they can cause a logjam of other things. For example, when do you normally adopt your appropriations bill? The end of session. Does that have a trigger effect to some other things? Yes, because in some cases you may not be able to pass other legislation without knowing that there's going to be funding for it. But again, can there be things that can help you fix that logjam? Absolutely. Some of the things that you can try to do is to manage the overall flow of your work so that early session time is used efficiently. You want to plan the time that you actually spend on debate and making sure that you're debating the important things, which I know actually when I was here you had a consent calendar versus a debate calendar. So you were taking all of those things that were very non-controversial and getting those out of the way efficiently by having a consent calendar. And you had practices in place that made sure that the things that were placed on your consent calendar were truly non-controversial items. And if there was any question, then it was automatically or pretty easily moved from the consent calendar to the debate calendar. Going back historically, because I said parliamentary procedure is tried and true, I'm going to quote a Delaware senator, Senator Everett Hale, from 1969, because some of the things he said then still apply today. How do you avoid or minimize logjam? You want to have pre-session organization and orientations. You want to have pre-session filing of bills. You want to have consent calendars, and you want to have some type of deadlines that you self-impose on yourself. And deadlines are the most common mechanism by which legislatures manage their overall flow of their work. But they're not a panacea. Deadlines are as good as the members and the leadership as they apply them. So without leadership and without members calling attention to the fact that maybe sometimes deadlines aren't being followed, that's your role as part of this institution, is to make sure that that is noticed and followed. some of the common things we're going to talk about now is actually getting into more of the things that can actually streamline your process. One of the big things that they talked about is the early organization. What you don't have here in Minnesota that several states have by constitution are what we call formal organizational sessions. In Minnesota, what happens now is you have informal caucus organizations where you do caucuses and you select, the caucuses select their leadership or those people who are going to be put forth as nominees for official election on the opening day of session. During a formal organizational session, those things take place there. The organization takes place prior to the opening day of session. And the scope of those organizational sessions is literally limited to that, to organization. So it's the swearing in of members, it's the election of caucus and chamber leaders, other leaders or officers such as the clerk or secretary, sergeant may be adopted and selected. You may hire other staff because in some states that has to be approved. Staff hiring has to be approved. You may be able to get your chamber rules adopted or the discussion on them done. You might establish your session schedules or your deadlines. And sometimes they're ready and they will actually start the process of naming at least the names of the committees or numbers of committees, if not actual chairmanships and members. But what you do then, it is all formal because you have been sworn in, you have been officially organized as a body. Everything that takes place from that point on to the beginning of session is already, quote unquote, set in stone. What happens now in Minnesota, and I have seen this happen, where your caucuses select their leadership, but then by the time opening day comes, the person who was designated to become, in this body, Speaker of the House is not selected as Speaker. What happens then to all that pre-session work that has been done to that point? Well, depending upon who's selected, all that work may go by the wayside. And so the month or two that you've had prior to the opening day of session has gone for naught. Whereas in a formal organizational session, which normally occur anywhere from 2 weeks following the election to oftentimes the beginning to middle of December, from that point on, if you've had a formal organizational session, those things are set in stone. You've done your leadership elections. You've been sworn in. So you have not wasted the time, quote unquote, wasted the time before opening day. And you're ready to start work right away. I have provided as an attachment to some of the information I've given you some examples, actually the examples of the constitutional language for those states that have them, which are Alabama, California, Florida, Idaho, Indiana, Louisiana, New Hampshire, North Dakota, Oklahoma, and South Carolina, for example. Again, if you were to consider this type of change, this would be a constitutional change that would be required because all of these formal organizational sessions are established by Constitution. Something else you might want to consider that would require a constitutional change is a veto session. Because right now, Minnesota is one of the dozen states that has what we call pocket veto for the governor, i.e., in the last term, if a governor doesn't want a bill to go forward, they just have to not sign it and that bill dies because there's nobody, you have adjourned, sine die, and there's no one for that or no place for that bill to be returned. In states that have veto sessions, Again, these are established by Constitution, and what happens is after a few days after or set time after the end of session, usually following the time limit that the governor is given to sign or veto bills, the legislature can determine whether it wants to come in and consider any of those vetoes. So again, it's giving an institutional power to the legislature to determine what happens to those bills. And it's its choice whether it comes in and determines whether to override those vetoes or to process those vetoes. Every legislature should have that opportunity. In Minnesota's case, you may have it the first year of your biennium, but you don't have it the second. Because in the first year of the biennium, you're coming back so the bills can be returned. But in this case, in Minnesota, it would be something that would give you a little bit more power over what happens to the bills in the second year of your biennium. Another option, if you don't want to go totally to a veto session, is simply to change the constitutional language about what happens to a bill that is not signed by the governor. In many states, the options are a bill is signed by the governor and becomes law. A bill is not signed by the governor, but it would become law after a set time period, or the governor has to veto the bill. Again, it's something where you as a representative body and the body that is normally considered to be the people's body, you've passed the legislation. You've given the viewpoint of the people that you represent and the people of the state. So therefore, shouldn't a little bit more weight be given to the fact that the bill passage should go forward and not die because a single person doesn't sign that? Again, something to consider as an institutional strengthening mechanism for the legislative branch of government. A third thing, or another thing that you might want to consider, is giving the legislature the ability to call itself into special session. If you want to call this as a trend, this is probably one of the things that has been trending for more legislatures over the years. In fact, I believe Utah just gave itself this right with this last election because there was a constitutional amendment there. Wyoming's recently given themselves this ability. So this is, again, another legislative strengthening tool where the legislature has the ability, when it deems it important to the people of the state, to come into special session to do work and not only not have to rely on the governor to call you into special session based on the things that the governor may deem to be important. And this is important for a lot of states. There's some of the states where they've had differences of opinion with the governor. But you can also note that it is something that often is never have to be used. It's not a common occurrence for legislatures to call themselves in because the governor can read the writing on the wall and determines that, yes, this is something that I'm getting the pressure, and if I don't do it, it's going to be done anyway, so I might as well go ahead and make the call for them. Minnesota is one of 14 states only that does not have the ability to call itself in. The other 36 states have the ability to call themselves into special session. And again, this is a change that would require something to be done to the Constitution. Moving on, now we're going to talk about some mechanisms that you have a little bit more control over, because many of these changes now would be simply things that you would do or adopt as far as your procedural rules. The first thing I want to talk about is committees and committee procedures. Committees are created by a legislative body to help the body divide up the work and to be able to process more work. If you had to try to hear every single bill that's introduced and to hear public testimony by everyone sitting in the same room during session, do you think you would get very much done? Probably not nearly enough to satisfy the people out in the state. That is the purpose of committees, and that's why they're developed. It's a divide and conquer. You get to divide up the workload to committees. It gives members an ability to become somewhat the experts for the body on certain areas if you stay on a committee for so long. Committees' purposes are, again, there to look and hear from the public. It is in front of committees that the public may present their testimony, give their opinion. It is the only place generally where public testimony is taken. It's where the bills and things that are given to the committee are to be refined, and a determination is to a recommendation whether that bill should go forward or not. And again, I think the key thing to hear is to remember that committees make recommendations to the full body. People go, well, the committee killed that bill. Technically, the committee didn't kill that bill. The legislature itself allowed the committee to not bring that bill forward, because if the legislature itself really wanted that bill to be brought forward, it could pull it out of that committee and bring it forward. So again, try to remember that committee's power is to make a recommendation to the body, and anything that it does is at the will of the body. There are no correct numbers of committees. The numbers of committees across the country range from as few as 6 to as many as several dozen. Like, I think I've seen as many as 65 or more committees in a legislature. What you want to do in determining the number is you want to have enough committees to process the work, but you don't want to have so many committees that they get in the way and interfere with each other, especially if they have jurisdictions that are close, where all of a sudden it's confusing to a committee as to where this bill should go, and you get into disputes between the committees with close jurisdictions going, that bill should come to me, no, it should come to me. So again, you want to be careful when you're setting up your committees to make sure that you have enough committees, but you don't have too many committees. General rule of thumb is you kind of multiply the number of members you have by about 3, because usually most members are assigned to 3 members or 3 committees, and you divide it. So you can do a mathematical calculation if you want to approximate the number of committees you should have. But again, it's a guesstimate, and it depends upon the types of things that you want to focus on as a legislature. And again, as I just noted, nationally, the most common number of assignments to a member is 3. That's often because many legislatures divide their committees into A, B, and C groups, or 1, 2, and 3 groups, and a member is assigned to each one of those groups. And that's for scheduling purposes. Because again, legislatures work in buildings that have limited space, so they're usually trying to control and maximize the use of their committee space, but not get in the way of each other. And oftentimes, 3 is a pretty good number where it's easy for the leaders to schedule the meetings and assign meetings. So therefore, the membership of those committees don't have conflicts among their committees and their committee schedules. The other thing that's really important to remember about committees is that you are to do the work of the body. You are not, it is not the role of the committees to increase the workload of body. And that's what happens if a committee is not doing its work. If a committee is inadequate or incompletely doing its work, what you're doing then is pushing the committee work to the floor, which then consumes valuable floor time and is a major contributor to end of session logjam. One of the things that I've heard across the country is like in committees, and I'll hear it and I just cringe, and it's like, oh, we'll fix it on the floor, let's just get that bill out of here. That is not the role of the committee. That work should be done in committee first, and the committees should do their work as much as they can to make the floor time use much more efficient and effective. And I'm going to quote a book. This is a study of state legislatures that was done in the late 60s, early 70s. It's quite interesting how valid most of the information that in that book still is. But what it said is a legislature cannot function smoothly without an operative committee system, which means the committees should do its work and they should be set up according. The next thing I want to talk about is how you process your bills. Because the bills are the main mechanism by which you enact laws. I'm going to focus on bills much more than the resolutions that you may pass, because most resolutions are internal business, unless it's a constitutional amendment that's passed by a joint resolution. On average, an average legislature introduces just under 2,200 bills per year, based on data that I've compiled over the last, going back about 40 years or 50 years. Minnesota's average bill introduction is higher than that. You average just over 3,500 bills per year. So you're a little over 1,400 bills higher than normal. One of the...
Excuse me, we have a member who has a question. Representative Freiberg.
Thank you, Mr. Chair. I can wait too if it's your preference.
If you want to go, she could use a break, I think, right?
Yeah, I'll take a drink.
Sure. I was just wondering, I mean, certainly that average sounds high. I do know, though, that we have one of the larger legislatures in the state, in the country, I should say. I'm just wondering if you've also looked at the number of bills per legislator and if we're off the margin there. I mean, I know we had 4,542 bills introduced, but we also have 134 House members, which I think is among the larger legislative bodies. So that averages out to about 34 bills per member. And I guess I don't know if that's higher than normal or lower than normal or what.
Ms. Erickson.
I haven't calculated it per member. Again, sometimes that's very difficult to do because some of the other things that I'm going to talk about later, one of which is bill introduction limits on members, which affects then how many bills are introduced in a session. And so much of it is also just tradition on how legislatures process bills. Some of historically in Minnesota, you used to have, and I don't know if you still have it, but you had a limit on authors of bills in the state. So you used to be limited to 5 authors. So if it was a popular issue, you couldn't have every single House member sign on to the bill as an author, where in some states they can. They don't limit the number of authors. So when I worked here, if it was a popular issue, you could get 134 divided by 5 is what, 50 bills on the same issue, just simply because everybody wanted to have their name on that bill, but they were limited. So many of the other mechanisms also influence that number. Minnesota's average is, you're not too much above the average. New York is out of the ballpark high. They average closer to 16,000 bills per year. If you want to put that in perspective, again, larger state, medium-sized body. In Colorado, it averages a few hundred. And one of the reason it averages a few hundred is the bill introduction limits that I'm going to talk about in just a little bit. One of the things that also influences it in Minnesota is your deadline system. The Minnesota legislature does not have or impose on itself the most common deadline, which is a bill introduction deadline. In Minnesota, you can introduce a bill on the last day of session, where in some legislatures, bill introductions are done by the second week of session. You can introduce no more bills. And one of the things that happens with a bill introduction deadline is that actually helps your committee work as well, because then once the bill introductions are done, your committees know what their workload is going to be. Where if you have a continual influx of legislation coming in, your committees are never know when their workload is going to be done, even though they may have a deadline by which they're supposed to have their work done. And that's why the common deadlines are, one, introduction deadlines, which Minnesota does not have, a committee action deadline, a first House action deadline, a second House action deadline, and some of them even have conference committee deadlines. I believe is it Texas that has a conference committee deadline that all conference committees have to be finished at least 3 days before the end of session, and the last 3 days are limited to the consideration of conference committee reports.
Representative Freiberg, do you have anything? Representative Loeffler.
Well, thank you, Mr. Chair and Ms. Erickson. You referenced a much longer period of time when you were looking at these statistics on bill introductions, but they seem, Minnesota being so out of that didn't seem to jive with what I remember, and so I looked up quickly, and last biennium, over the 2 years, 4,500 bills were introduced. So we were, so that's, a little over 2,000, 2,200 a year. The biennium before that was 4,000. The biennium before that, 3,400. They tend to tilt towards the first year of the biennium, which is our longer term. And so we really actually look like we're very average when you look at least our recent history. But I'm wondering how many of the legislatures that you look at operate like we do on a 2-year biennium, where the bills introduced in the first year are available for consideration in the second year. Sometimes bills are introduced in the first year just to give a signal that that's something someone's going to be working on over the interim and teeing up for the next year. The nature of the bill sometimes changes between the first and second year in terms of policy more in the second year, budget more in the first. But is that unusual to have that 2-year sort of planning cycle?
Ms. Erickson?
No, that's called carryover. And if I remember correctly, and I didn't bring those statistics with me, but I can make sure you provide that. I do have that information. About half of the states have carryover, if I remember correctly, where they carry over from usually in most states, they carry over from the odd year to the even year. There are a couple of them, because they're off-year states, the Virginia, New Jersey, carry over from the even year to the odd year.
Any other questions? Ms. Erickson?
I've referenced bill introduction limits. And there are about 20 chambers that have historically do and have done bill introduction limits, and that is literally a limit on the number of bills that a member can introduce. Almost all of these are established by chamber rule. Louisiana is the only one that put it in their constitution, which is not something I would recommend if you're starting out to do this. I would try it by rule because many of them, when they first implement it, tried it and determined that they did want to change the number of bills that they limit their members to. In Colorado, Colorado legislature usually operates under this one of the strictest, which is 5 bills per member per year. So again, hence the reason in Colorado the average number of bills introduced in a session is around 600 or so. They do have mechanisms in all of the states pretty much that use these limits, do have mechanisms for emergency situations where they have a late file bill or they have something truly an emergency that is local to theirs. They can circumvent or get around that limit. And in many cases, they also do not include certain types of bills. They may leave out local bills. They may not count them towards your limit. They may not include the appropriations bills that must be introduced by someone. In some cases, they don't allow committees to introduce bills, so it has to be by a member. So they would exempt those from the limits. But again, it's another mechanism by which you're controlling the volume that is flowing into your system. In California, the limits are, I think, 40 to 50 bills per member per biennium. So again, you can adjust the bill number as much as you want, but they usually try, in Virginia, when they first implemented it, I believe they started different number for the House and Senate because they established them by joint resolution. And they gave the senators more bills than the representatives because, again, the size of the chambers and the number of people they represent. So it is something for you to think about, but it is another mechanism that just simply controls the volume of work that you need to work on. And it really makes the members focus on those things that are truly important to them if they can only introduce 5 bills.
Representative Liebland.
Thank you, Mr. Chair, and thank you. This is an interesting discussion because I'm sure that you're aware that this is one of the ideas that's been proposed here. And so I'm wondering, when we talk about the goal of limiting the amount of work by limiting the number of bills a member can file, you know, when we compare to other states, I'm assuming that in some other states, introducing a bill may have a somewhat different meaning than it does in Minnesota. For instance, if you only get 5 bills, I assume there's got to be some guarantee that your bill is going to receive some further consideration. Whereas, you know, I guess my question is about that. Whether there are differences between states in what happens to the bills once they're introduced. Because when you talk about the workload, in Minnesota, members introduce bills for a number of different reasons. Sometimes, as Representative Loeffler mentioned, it's to put something in front of the public to signal, I want to get comment on this bill. Mm-hmm. It's not necessarily intended, especially if it's introduced at the end of a session, it's not intended that a committee is going to pick up that bill and give it consideration at that time. Mm-hmm. And in fact, we have to ask for a bill hearing if we want a bill to be heard. So can you give us some sense as we talk about you know, the workload of having a lot of bills introduced, how different states deal with, you know, what is the meaning of introducing a bill? Sometimes, is in every state, does that bill get a hearing if you only get 5, for example?
Ms. Erickson.
It varies. As I said, one of the public dissatisfaction things that happened in Colorado, which changed the Constitution in Colorado, is now in Colorado, every bill must be heard and reported. And there are other chambers and state legislatures that also hear and report all bills, or must hear or must report. But more often than not, they're much more like Minnesota, where the committee chairmen are given much more control over determining the agenda, which bills are heard, when bills are heard, and even individual members, like you said, here in Minnesota, that a member must require or request a hearing of a bill before it goes forward. So in that sense, I think Minnesota's process is much more like the norm, and Colorado's is probably more the abnormal, where they do require all bills to be heard and reported. And the bill introduction limit, however, in Colorado was imposed before the limit on or the requirement to hear and report all bills, so that they were about a decade apart. I think they started the introduction limits in Colorado in the late 70s, and the other restrictions weren't put on until probably the late 80s, mid to late 80s or early 90s. But you're probably more in the norm on the other type of processing of your bills, the committee consideration, why members introduce bills upon request, because you are being requested sometimes by either an executive branch agency or a constituent back home to fix something, and you're putting those ideas out there. So I think that is probably a more normal processing of bills, and why you're probably closer to the middle in the average of bills introduced.
Ms. Erickson?
One of the other things I was asked to talk about a little bit was omnibus bills, which is basically a definition of a bill that has a lot of different things added to it. Whether they relate to a same subject or not, it depends upon the state you're in. One of the things that tends to control these and why most legislatures have to work on one of these is the single subject requirement of constitutions. And these actually were put into place historically because of public dissatisfaction and concerns over legislative processing of bills that had too many things going on and nobody knew what was in them, and it was a corruption issue in some of the states when these went in, but then it was something that was adopted across most states. And in Minnesota, yours is Article 4, Section 17, which is generally a fairly standard language for a single subject requirement, in that it states no law shall embrace more than one subject which shall be expressed in its title. If you want to control omnibus bills a little bit more, you could actually strengthen that language to be more similar to a couple of other states where their language puts a restriction not only on the subject but on the scope and the object that can't be changed, and you base it on its original content, purpose and title. You can't change the scope. So some of these other ones have a little bit stronger terminology or terms in their constitutional provision for a single subject. So that would be a mechanism. Again, that change would be a constitutional change. How you can fix that more internally, if you want, is to strengthen what we call your germaneness rules. Because again, Minnesota's, your germaneness rule probably is more of the generic germaneness rule, i.e. it's supposed to be related to or in close relationship to something. But many of the other states, like their single subject requirements, may have stronger terminology or stronger language in their germaneness. Again, i.e., it can't be changed from its original purpose, original scope, or object. They may limit title amendments, so you wouldn't be able to change the title of the bill. But all of these, when you get into a germaneness discussion, that is a subjective thing. And it can be one of the hardest things for a chairman or a presiding officer to determine. So I've given you a little bit kind of the checklist, the common checklist of things that you can look at when you're trying to determine whether something is germane. Again, does it deal with a different topic or subject? Does it expand unduly the scope or object of the bill? Is it an independent question? Does it flow in a natural or appropriate manner to what was originally intended? Would it change the scope or purpose? Would it change one type of motion to another? Does it require a bill title amendment or change? So some of those things can give you indications whether something is actually germane or not. And these are the things, the single subject requirement and the germaneness are things that affect whether a bill can be turned into an omnibus bill. Why do you use them? When I worked for the legislature, you saw some omnibus bills, but often those came about as a result of an interim committee doing significant work to a section of law that may have covered a broader topic area and required, multiple changes to different sections of statute. But it was a concerted effort to have a relationship between a logical relationship between all of those sections of law. For example, one of the workers' compensation or on health care. So you're working with bigger sections, and it was put out after an interim discussion. Usually, as you said, the committees put that work over so it could take a longer, more close look at those. In some cases, in some states, the appropriation bill becomes an omnibus bill because they don't have a limit on their appropriations bills. Other states literally, again, the single subject requirement in and of itself doesn't apply to their appropriations bills, but they may have specific language that limits the appropriations bills to appropriations. And that if you were doing any policy changes, those would have to come in a separate bill. Or they may restrict what they call general appropriation bills to literally the appropriations for the different branches of government.
Ms. Erickson, Representative Freiberg has a question. Representative Freiberg.
Thank you, Mr. Chair. Ms. Erickson, just a question about these constitutional provisions. We have one in Minnesota as well, but I know the courts, the Minnesota court system has been reluctant to enforce it in a way that it would invalidate any legislation. I think the test that's used is as long as two subjects are connected by a mere filament, they'll pass muster. So, any connection to government or something, for example, might qualify, which basically means any two subjects you could find some way to argue that they're connected. I'm just looking at the Michigan provision. Do you know if the courts in Michigan have actually interpreted that in such a way as to invalidate legislation because it violates the single subject rule? And the Minnesota courts might be different than the Michigan courts, I realize, but just sort of curious how effective that's been.
Ms. Erickson.
And again, that is one of the things where the courts do play a role in how strictly they interpret the legislation or the simple language. Even states where they have language much more similar to Minnesota's, the courts have more closely looked at the word subject, and they have more narrowly scoped it. Minnesota's interpretation has been broader than many of the other ones. So I'm going to guess in Michigan's case, because they have a little bit different language where they're basically saying you can't change the original scope or object of the bill or can't change it as introduced, the courts may look at that more narrowly than they would the Minnesota interpretation. I haven't looked at the number, specifically the number of lawsuits and interpretations. I did ask a question a few years ago on if there has been a change in the interpretation, and most of the people said no. That has been something that the courts have determined many decades ago, and it's been pretty standard since then. But again, I think just the language difference, the courts are going to take a different look at the terminology of structure.
Ms. Erickson?
And that,
Representative Mason, did you have a question?
I do. I actually have.
Representative Mason.
Thank you, Mr. Chair. I think recently we had what I would call a super omnibus bill, which is way out of line. But my question is, both dealing with the omnibus bill and germaneness, and as long as I've been in this body, germaneness tends to be more of a game than it lacks enforcement would be the general way I would put it. So how do other states have a better way of enforcing an omnibus bill that to make it have only one topic? And also how do you deal with the germaneness on the floor as well? So it really means something.
Ms. Erickson.
again, that's when I originally started this, that's where you as members and where your leadership comes into play. You can have a lot of rules in place, but if you as members and if leadership don't want to enforce them, then it's not like having rules. That goes to deadline rules, it goes to germaneness, it goes to any type of rule. And it's how leadership and you as a body determine what you want your institution to be. If you want those rules enforced, then you can do that by a vote. You can basically say and give indications to leadership that you want those enforced. And again, it comes down to the personalities and the people that come to this institution. As I like to also say about the legislative institution, it's probably the one quote-unquote business that doesn't get to hire its employees. The people send them to the institution, and the institution must work within with the people that come, that are sent here to be the electorate's representatives. And as you probably are well aware, sometimes the blending of the people that come here works really well, and you get a lot of things done. There are other times it's more like oil and water, and they don't like to come, they like to separate. So it is something that you as a body need to be aware of when you're working together, and to think about what do you want this institution to be and how do you want it to function. And a long-term former Secretary of the Senate in Florida, analyses of germaneness is, yes, we have those rules, but also he who has the votes has the germaneness. And that's the point I think that you're trying to make, which is true. But again, it does come down to how do you want to view those germaneness rules, and how do you as members want to uphold them or not.
Thank you.
Ms. Erickson.
The other thing I was asked to talk about, which also gets a little bit into the omnibus bills, is what we call the defeated bills or issues. or it could be in progress bills or issues. In many, or in some legislatures, they have very specific rules that basically say if a bill or an issue has been defeated, it cannot be brought up again as a bill, or it cannot be introduced as an amendment into another piece of legislation. That's true because most legislatures are like Minnesota in the fact that you're limited in session. You have limited time and limited resources to go about processing bills. So once you've made a determination on an issue, it should be done. And you shouldn't have to keep coming back over it and taking the same vote on it. And again, that's part of the reason you have the single subject requirements too, is to make sure that you're not putting things into bills that many people don't like, or attaching things to bills where people really like the original bill, but you're adding things that they don't like into it to get people to vote for things that they don't like. These are all things where it, again, as an institution, you make a determination, we've done this, we aren't going to deal with it again. So we're going to have a rule in place that basically says, once it's been tabled, it's been defeated, it's not going to come back again. We're not going to have to deal with it. Some of the rules also, and I think I used it as an example someplace in here, that also says you can't use an amendment, include as an amendment an issue or the substantially same language as something that's in progress. Because then what you're basically in effect doing is, especially if it's a floor amendment, you're circumventing your committee process and you're circumventing public input and testimony on that issue. So you can do it either two ways, or you can have both, which in some states they do. You can basically say, once we've dealt with an issue, you can't bring it up as an amendment or another bill. Or if it's in progress as a bill, you can't bring it up as an amendment and try to incorporate it. Again, giving the structure and the work of this body more weight. You're basically saying, we believe in our committee system, we want our committees to work, and we want the public to be able to have input, so we're not going to allow amendments of existing language, but we also don't want to have to go over the same issue again and again and again. So if it's been defeated once, you can't bring it up as another bill or an amendment. That, however, for this body does not preclude a bill coming over on the same topic from the other chamber. For example, you do have companion bills here, so you would still have oftentimes a companion Senate bill. That bill could come over. You just wouldn't be able to bring up another House bill or House amendment of that same issue. And in closing, these are all just ideas and theories for you to think about. I really want you to think about your institution and how you want it to operate. I think those are the important things, that you each are individuals and each chamber is independent of each other. So what they do in the other body doesn't necessarily have to influence on what you do in this body. But your strength also comes as being individual thinkers within your own body and using your voice to uphold if you see something wrong or something inappropriate or something that you don't think is working right. Use these opportunities to voice those opinions and use that on the floor as well. If you're seeing something where something's being done inappropriately, you have points of order, points of parliamentary procedure. You can call those to the attention of the body. And again, sometimes will you always win? No. But that doesn't mean you shouldn't try. And again, I'm going to go back to a final quote from my favorite person from the state of Minnesota, Mr. Burdick. And this is to commend you on what you're doing here. And his quote was, "The vitality of government flourishes when public officials continually seek to better the institutions they serve. What's essential is the willingness to look for weaknesses or to identify processes to be revamped. Otherwise, policymakers end up trying to operate modern legislatures with old rules and procedures. I will add a caveat to that. However, just because it's old doesn't mean it's bad." Coming from a now senior person. And again, I just want to commend all of you, especially for taking your time and showing up and having interest in this topic, because again, I love state legislative institutions, and I want them to be a strong, vital, co-equal branch of government with everybody else, and anything that you can do to make this legislature vibrant and dynamic and strong and co-equal is worth trying to do. And with that, if there's other questions, I'm open to them.
Thank you, Ms. Erickson. Any questions or comments? Representative Freiberg.
Thank you, Mr. Chair. Sorry to keep asking questions here. So the focus here was mechanisms to streamline the legislative process. One rule I know that we don't have in Minnesota that some other states have that we've talked about periodically is prohibiting the legislature from meeting after midnight. I suppose we do actually have that rule. We just frequently waive it. But I know at least in some states, I believe that's a rule that cannot be waived. Do you think, I guess I have two questions, how many states have a rule like that that cannot be waived? And secondly, how effective do you think it is to streamline the legislative process?
Ms. Erickson.
Are you talking about the requirements for readings that have to be on separate days that are by calendar day, or are you talking about what we call, in some cases are called the family-friendly hours, where they don't meet in session past 9 o'clock?
Yeah, my understanding was at least some legislatures have, we have a rule, I know that the House can't meet in a floor session after midnight. But we do periodically waive that, waive that rule, I guess, by majority vote. So I hadn't heard about ones where it's 9 o'clock, where it's as early as 9 o'clock.
There are several states where in their chamber rules, they put committees cannot meet past, and you pick the time that you want to. And again, they deem those to be what they call family-friendly, because you have families, your staff has families, and they were trying to respect sometimes the time of the people who work for the institution who have outside family lives and things to do. So there are several chambers that do have those rules, and if you would like examples of those, again, I can make sure that I can update that information and get it to you. Again, with the caveat that I'm going to be giving you last biennium rules, which might change for this biennium.
Representative Mason.
Thank you, Mr. Chair. I'd like to go back to maybe clarifying the formal organization that you talked about. And again, one of the things that takes place during the formal organization is that members are sworn in. So in order to have that done, and our session starts like the first week in January. So does that mean the states that have formal organizations, they actually do their swearing in before January?
Ms. Erickson.
Yes, that's true. All of that takes place at the formal organizational by constitution. So your term of office begins at the formal organizational session, not the opening day of session. So it just switches when your term of office begins in those states. For example, in Florida, by constitution, again, these are constitutional provisions that establish those. So in Florida, by constitution, their formal organizational session is 2 weeks after the election. I believe New Hampshire's is the first week of December, and they'll pick, it'll be the second Monday after the third, whatever. However, the constitutional language you want to put it, they'll put it, usually the second Tuesday or second Wednesday or third of December. In California, in Maine, actually start their legislative sessions in early December. But what they do in those states, 2 states, is they organize by statute, and then they recess and reconvene in January to be much more similar to what we would call normal legislative session. But yeah, those organizational things, literally the swearing in and all of that is done at a formal organizational session. Hence, what you're doing from that point forward then is truly official legislative work. There is no concern that when you come to opening day of session, that your leadership is going to change unless something severe happens in those times and you choose to change it. But normally at that point, those decisions are formally made and you formally go forward. And literally on opening day of session, if all of your committees are in and you've been pre-filing bills, you can literally start work on the first day of session.
Thank you.
Representative Liebling.
Thank you, Mr. Chair. I'd like to focus on something that I think is an actual issue here in our legislature. So I think we've seen from time to time, and I'm sure other states see the same thing, that there are times when members, particularly members who are in the minority at that time, who use amendments as a way to either have a gotcha and just to, make other members take a bad vote or take a vote on something, or just simply to waste time. And there are various ways that we have attempted to deal with this in this legislature. And one of the issues, I think, that is a significant issue that's before us now as we go into our new session is the issue about pre-filing rules for amendments. So about 6 years ago, for the very first time, as I understand it, in this legislature, a rule was passed that said that in order to have an amendment considered on the floor, you had to file it 24 hours in advance. Well, I think well-intended. I was opposed to it then, just in full disclosure. And I think that it's had a significant effect on the body in that when amendments, leadership on both sides know what the amendments are 24 hours ahead. Everybody goes into their caucus rooms, discusses the amendments before they get to the floor. And then I believe it's had the effect of what I would call dumbing down the floor. In other words, members no longer really have to pay attention. You can go in there with your list. I'm voting yes on this one, no on this one. And so it has had, I think, a very unintended effect of allowing members to not pay attention. Body is there, brain does not have to be engaged. So I'm really curious what other legislatures do about pre-filing amendments for the floor, if they do this, if they have other ways of managing what is really a very real problem of how do you strike a balance of trying to control the floor so that people just don't waste time and attempt to really, use the process to slow any progress, at the same time respecting the right of members to have their voices heard, to actually work on a bill, try to really bring an issue before the body. So, I realize there is no perfect process, and we're always struggling to get the process the best we can. So how do other states manage that issue, and specifically this issue about pre-filing, having a pre-file rule?
Ms. Erickson.
On pre-filed floor amendments specifically, again, as you indicated, it does vary. I don't have the exact language with me or the exact number, but there are states that do require pre-filing. The timing of it may vary. Some of them, it's not 24 hours. It could be, the morning prior to session. some of that, in some of the states, they require that because of their computer systems. They needed to have time because they put barcode scans on things, and so they needed time to have that set up. So some of the reasons why they required the pre-filing and the amount of time for pre-filing, some of it was more of a drafting concern and making sure that it was something that they could put up and have in the systems for members to be available. And other times it was, again, to be more transparent with the information that was out there. But the timing of it differs. Like I said, it can be from, like you said, here in Minnesota, 24 hours. It could be as much or down to at least even an hour ahead of time. So the rationales for why they do it is different. I hadn't heard that argument about before from the states that did it, about the caucus and things where it's removing some of the discussion from the floor. I had not heard that as much. Or you could be like Oregon, and one of the chambers in Idaho, I believe, they don't allow floor amendments at all.
Wow.
If they want to do, if it's a major, they may allow a small technical amendment to come through, but if it's any type of major amendment, especially in Oregon, the bill has to be sent back to committee.
Representative Levy.
Chair. Thank you, Mr. Chair. And a kind of a corollary to this is having a 24-hour rule in committees. So this is something that in our legislature is basically up to the chair whether they're going to have a rule that amendments have to be pre-filed for committee. I found that with my personal opinion is that when you have that on the floor and then you also have it in committee, it pretty much takes away your ability to work as a committee and actually work on bills, because you don't get a chance to have the discussion and then go, oh, here's something that needs fixing and let's fix it. It just really slows things down. But I'm wondering, how do other states deal with that issue? Do committees tend to have rules like that? Is it just all over the place? Is there any sort of thinking by those who think about these things about what is the best way to manage committee work along those lines, or anything you can help us with?
Most of the information that I've heard about pre-filing has dealt with floor amendments. I don't have the information on committee processes, but I can find that. I would probably think that that's less common to have major things done in committee, again, because that is supposed to be a more free and open debate time where you do raise the issues. So I will check into that for you and find out, but I would be probably more leaning towards that would be more unusual in committee. Some of them are more likely to require pre-filing if it's a major amendment, i.e. if it's more than a page or two, where you're making more substantive changes. Some of them, they don't require pre-filing of what would be more technical or smaller amendments. They don't require those to be pre-filed. But I'll check on the committee information, because that is, again, something where I've heard about it more for floor amendments, not so much for committee amendments.
Thank you.
Representative Wagenius.
Thank you, Mr. Chair. I appreciate your talking about work getting done in committee, because that's where it's supposed to be done. There's been a recent habit here of a bill needing work, and the committee chair will say, well, you get that fixed before it gets to the next committee, which means the public has no idea what is going on. The transparency is just gone. So have other legislatures faced that same problem, and how have they handled it?
Ms. Erickson.
You are not alone in being that. That's why I say I've heard that terminology, we'll just fix it on the floor.
Well, I'm talking about between committees.
Representative Agenius.
Thank you.
Ms. Erickson.
It's going to depend upon whether in other legislatures they do multiple committee referrals, because they may not. And they do in a few chambers that I'm aware of, but in many of them, depending upon their session length, it may go to one committee and then they don't go to another committee unless it comes to the floor and they basically goes, yeah, we have to refer this to another committee because it really deals with another issue. But again, I think that is the type of comment that I would say you want your committees to do the work, especially if it's going from one committee to another one. You might say that that committee still has the opportunity, it's still being worked in committee, and somebody could come and testify. Personally, this is my personal opinion, you'd still want the committees to do more of their own work. Because again, you want public testimony in that committee on the issues that belong to that committee. Because the next committee, that might not be their jurisdiction.
That's right.
But again, having a second committee out, it may still be better than having it sent to the floor where you can have no public testimony on that bill.
Representative Pinto.
Thank you, Mr. Chair, and apologies to you and to the testifier for having arrived so late, so I missed quite a bit of the presentation. My question has to do with proposals regarding conference committees. I noticed the chair's report from 10 years ago has several suggestions regarding conference committees, but I didn't see that addressed in your discussion so much. And again, perhaps I had missed that because of arriving so late. But it does seem like that's there have been a number of concerns expressed in our legislature about conference committees, being really difficult to track. They're meeting at 3 in the morning, and in some cases are completely replacing the text of a bill with sometimes subject matter that was not considered by either body, et cetera. I'm just wondering if that's an area that there's a particular reason that you would not address that area, if you can just discuss that a bit.
Ms. Erickson.
I didn't bring up every topic that I talked about before, but in Minnesota, I believe, if I remember correctly, it had been the House that had limited scope conference committees, but the Senate had open or free conference committees, and so you're actually building in conflict in the type of conference committees you use. In many states, the conference committee rules are established by joint rule, and they are either determined to be limited scope, which means you can only take up those areas in which there is a difference of opinion. You can't bring in new information, versus a free conference committee in which you can take up anything and then add in new information. We did discuss briefly that in some states they do have deadlines for conference committees, and in other states they probably they apply their meeting rules to conference committees as well as they do to regular committees, so they have to be noticed, and they establish timeframes within which they must work. So there are some other things that Minnesota could look at as far as establishing the different types of conference committees and the types of conference committees they have and the structures and scheduling of those conference committees that might be applicable to fix that. And the family-friendly hours, they could apply standard committee rules to conference committees as well.
Ms. Erickson, we have had numerous issues where conference committees have never met publicly. So there's been no public input as to what was going into the conference committee report. It was shuttled back and forth, usually by the chairs, and then they would come back with signatures or without, and that's the conference committee report. The erosion of the conference committees has been another real issue here. Mm-hmm. At one time, the conference committees met at a regular scheduled time. Mm-hmm. There was public input, and there was a deadline. Your conference committee was to last a week or 2 weeks, but whatever it was done. That is almost all totally eroded away from us. So these conference committee reports come in, and frankly, only the person that may sign it, and I doubt whether they even know what's in the conference committee. So that is another area we need to look at.
Yeah.
I'm going to ask you to bring one other area up, and you've alluded to it, technology. Technology, at one point, used to slow us down. A bill had to go to the printer. That took 24 hours. So at least there was 24 hours to look at the one copy that you had, and particularly with the larger bills. And now we can almost instantly put a bill up online, and then there's the bill. It becomes an issue with us about when you've got 4,542 bills that are introduced, and all of these are in play literally at one time, and you add the technology to it. So how have states dealt with technology and the use of technology?
Technology in the legislative process is a very interesting thing. I always like to say, is the process driving the technology, or is technology driving the process? And that's a determination that you, as a body, need to work, because technology can be very beneficial. It can allow you to put all of that information up and have it available publicly so people can see it. It is not something where somebody has to be able to come down to the legislature to pick up a physical copy of the bill. So in many cases, the transparency usage of that technology is very positive. The other side of that is they may want things to happen faster, because, again, we can get this done faster, we can process it faster. That's where you have to stop as an institution and say, which is driving which? Do you want the technology to drive your process, or do you want your process to drive the technology? So again, you do want to take careful consideration of how you want to use technology to better affect your process and to minimize the impacts, the negative impacts that it can have, because it's, more demands and faster. Yes, you can get it done faster, but should you get it done faster? In some cases, they do require anything, whether it's electronic or paper, because they have constitutional requirements, again, for things to be printed and available to members for a set amount of time. Other places require legislation to lie on a member's desk for, a day or two, or at least 12 hours. So you can, again, control that technology a little bit by some of your deadlines, by some of the things that you can impose where it has to be available for a set amount of time before you have to process it. But again, carefully thinking about where technology can improve your process and where process has to slow technology down.
Further questions from the members? No further questions. Ms. Erickson, thank you again. I assume we're going to be in touch with you over the next couple of months. We have one more hearing tomorrow, and again, these are informational hearings. These are to make sure that everybody understands that there will be some consideration of some changes in the Minnesota House and probably with the Minnesota Senate and the joint rules, and those may even be constitutional, depending on what the body wants to do. We have a whole list of testifiers tomorrow, but we will continue. Now, Speaker-designate Hortman has said there'll be a subcommittee in rules with only one objective, looking at this process and refining it, which is where it should be. It should be in the Rules Committee. So with that, if there's someone tonight who wishes to make a brief comment, and remember, brief, Judge, you wish to come down? Come on down. And thank you again, Ms. Erickson, for doing this. And all of her testimony and materials are online. So they'll be on my House website because that's all we've got.
Thank you again, and I will talk to some of you about any other information that you have. My contact information is there, or I have business cards as well, so you can just let me know what things that you would like me to present or provide to this committee as well.
Welcome to the committee, and please identify yourself for the record.
Thank you. Jack Davies, former state senator, 60 years ago. I started. Mr. Chairman, members of the committee, I thought maybe I could save myself a trip over, but I'll come over tomorrow. I just wanted to make the point that this committee has to remember this reality. There are 5.5 million Minnesotans out there with a lot of ideas, and some of those ideas are there ought to be a law, and some of those there ought to be a law are brought to some of you to be introduced, and some of those ideas are not really developed very well. And what the job of the legislature is to try to figure out which of those ideas are sort of good and then fix them up, which means reading the bills and thinking about them and offering amendments and so on. And the more open the procedure is, the less artificial rules there are, the better that job is done. The pre-filing of bills, of amendments, for example, is unbelievably destructive because the members of the House and the Senate are not able then to read the bill when it comes up on the floor and, hey, there's a grammatical mistake here. And the problem is every time there's a grammatical mistake, there's an underlying substantive mistake behind that mistake. Or they cannot think, this would be better if we did this way. And on the spur of the moment, offer the amendment, explain the rationale for it, and then have the House decide whether that explanation in that case for that amendment works. And I just wanted you to sleep on that overnight.
So, Senator, we will see you tomorrow.
You'll see me tomorrow.
All right, and we will have his testimony. We already have two, and it'll be posted. So,
But
thank you again.
very much for giving me that 3 minutes.
We'll give you much more tomorrow. Somebody else wants? Come on down. Please identify yourself for the record.
Sure, please. Tom Diamond. What I wanted to...
Could you say that one more time?
Sure. Tom Diamond.
Okay, thank you.
I used to serve as a committee administrator in the Senate here, and also I've served as an elected official, city council member in the city of St. Paul, so a little bit background of working through the processes, but I'm also a veteran, and I work on veterans issues up here at the legislature, advocating at volunteer work, trying to make sure that veterans get their benefits and the care that they need. And I must say, with the limited experience that I had working with legislative processes, I find that it's very disappointing, and that I think it's not serving those elected officials who are trying to do a good job for the people. And I certainly don't think it helps public participation in the process in many ways. But I will just speak of one piece of it that I find very troubling. And again, I'll speak in the context of veterans issues. Try and come down and speak on behalf and why different programs are or are not, or proposals are or are not helpful in getting care that veterans need, and encourage veterans to come down here and speak also their perspective. And those votes and those bills are never voted on. It's all referred for further consideration. We never know what your position is from anybody, and it's very difficult to then go back and talk to people and stuff because you don't know what they're, and there's no, if you have a vote, there's usually would be some discussion as, well, here's why I would vote, or here's what I think we ought to adjust to do it. It's just, okay, let's go on for further consideration. And then we never know how it ended up because it just goes into a dark room, and someday it comes out, and oftentimes not only comes out one piece of legislation or another, but it's been changed. So it may have a different meaning and may have a different practice and stuff. So it is very difficult to encourage people to be active in the process and to speak up on how they can help out their fellow veterans when they run into that kind of process and they don't see how what they are doing helps or doesn't help in the process. And so I would just encourage you to look at that part of the process and see whether there's a better way to do that. Thank you. Appreciate it.
Thank you. Anyone else? All right, seeing no one else, thank you again, members, and we will meet tomorrow, and with that, meeting is adjourned.